Afternoon, Vladimir, students and guests. I'd like to talk to you today about certain aspects of the English legal system as they affect commercial law and indeed business law. My talk will cover the following areas. First, judicial interpretation, common law versus legislation. Second, the doctrine of precedent and how it is applied by the courts. Third, some contrasts between common law and continental systems, pertaining particularly to procedure before the courts and the judiciary. Finally, the interplay between common law and equity and how this applies to commercial practice. But first, I would like to deal with a question which frequently occurs in this context regarding international commercial jurisdiction. Namely, where exactly does English law apply? To answer, we need a short geopolitical tour of these islands in order to distinguish between Britain, Great Britain, Northern Ireland, and the Republic of Ireland, and indeed the United Kingdom. Britain consists of all the countries on this island, namely England, Wales, and Scotland, while the UK is Britain plus Northern Ireland. Britain and Great Britain are the same thing. The Republic of Ireland is a sovereign, independent state. From an international jurisdictional perspective, it is important to keep in mind that there is no such thing as United Kingdom law. English law applies only to England and Wales, which is regarded as a single jurisdiction from an international jurisdictional perspective. Scotland is a different jurisdiction for the same purposes as is Northern Ireland. The Republic of Ireland is not part of the United Kingdom and is a separate jurisdiction altogether, with its own laws, constitution, political system, and parliament. Although it is part of the common law countries, like Canada or New Zealand or Australia, Irish law does not apply in the UK and vice versa. With common law systems in general, judge-made law rather than codified law is at the heart of the system. Nevertheless, legislation or statutory law, as lawyers call it, is also a very important source, with statutes being interpreted to give effect to the intentions of Parliament as far as possible. If no legislation exists to cover a particular dispute, then case law applies. And if no case law can be found, then customary law, or in the final analysis, business practice can apply. However, this last scenario is highly unlikely in today's complex legal world, where legislation and case law seem to cover every aspect of our lives.